Good morning. It's time for the Tuesday morning update. I'm Mitch Beinhacker. I'm a business attorney in Clark, New Jersey. I handle business transactions, estate planning, and I'm the host of a podcast called The Accidental Entrepreneur. You can find me on all the directories. So today, I'm going to talk a little bit about rental properties and liability that you may incur being a landlord. Always thinking of what to talk about on these short introductions, and somehow some question pops up. Somebody calls me about something. So I got a call the other day from a good friend of mine who's an insurance broker who has a client who owns a rental property, maybe a two-family home or something like that. And they were talking about whether this person should take the property, put it into some sort of an entity, like a limited liability company. And by the way, this is in New Jersey, not speaking specific to any other state, but generally, the rules apply in this applies in other states. You should just check with local counsel. So the person didn't want to be bothered with forming an LLC and putting the property in the LLC, which would be retitling the LLC, open a bank account for the LLC, getting a tax ID number, all those types of things. They wanted to just get an umbrella policy. So, as a lot of you may be aware, if you own a rental property or even with your home, you have general liability insurance, probably up to $500,000 of coverage. And then very often what is recommended, and what I certainly recommend you do, is you buy something called an umbrella policy, which is an excess liability policy. Could be for $1 million, could be for $5 million, could be for $10 million. Depends on your net worth, assets you have. And you would purchase this policy, and the reason it's called an umbrella policy is because basically it sits over all of your other assets. So if you have a claim of some sort in excess of the base liability limits of $500,000, you get a $2 million claim, and you have a $5 million umbrella, the umbrella policy would pay the claim up to its policy limits. In this case, would be $5 million on the policy. So if somebody trips on your rental property, for example, or a tenant has a complaint of something and sues you, your general liability policy would kick in, and then your umbrella policy would pick up the excess. In theory, that's not always the case. There's sometimes where insurance companies, refuse to provide coverage, depending on how the scenario came about, what you did and what you didn't do. Maybe you forgot about some local ordinance or something. Very often insurance companies, the way they protect themselves, their job is to collect premiums and not pay claims. I'm not criticizing insurance companies, but that's certainly happens from time to time. Sometimes you have to demand that they provide coverage to you. And if they do, they go out and they hire their lawyers to defend you and handle the lawsuit. If you own a rental property and you don't put it into a separate company, like an LLC, for example, that's my choice in most cases, you will get sued personally. They will name you, and they may sue you personally anyway, but if the property is owned by an LLC and you've been following the rules you're supposed to follow in terms of managing that LLC and keeping everything separate, you personally will be dismissed from the case in most cases. It's not always the case, but very often you will get out of the case. So a lot of times the comment is, the analogy is used, you don't need belts and suspenders. So if you have a liability policy, you don't need the suspenders of an LLC. Well, that's not always the case. And I recommend that people always put properties that are being used by other people, tenants, you being used for commercial purposes, in a separate LLC. Separate LLCs if you have multiple properties. The reason being that it will protect your other assets and you personally if you're following the rules. There are, there are some burdens that it puts on you. You have to definitely set up a bank account, get a tax ID number. You're going to have an operating agreement. You're going to have to keep separate books and records. You're going to have to deal with the tenants on behalf of the LLC, not in your own individual capacity. You need to be collecting rents in the name of the LLC and depositing into those accounts, into that bank account, not your personal account. Pay for all of your expenses of the property through the LLC. From a tax standpoint, and this is more, you should have this discussion with your CPA, but very often CPAs like LLCs better because they're a little bit cleaner from a bookkeeping standpoint. You have separate books and records to show what your expenses are and your income, and take your write-offs and so forth. Now, if you have multiple properties, you may want to consider something called a series LLC. Now, there are a few states, Delaware being one of them, and a couple other states in the country, that have an entity. It's a variation on a regular LLC that basically allows you to set up an LLC holding company with little sub-companies below the main company called series, and you can call them anything you want. You can name each series the property address. And it allows you to kind of group all your properties together. But if you keep separate books and records for each property, they're separated for liability purposes. It's a much easier way to do it if you have, 10, 15, 20 properties versus one or two, because you don't want to have, 20 LLCs and 20 filings. It's a lot easier. It may save you money in legal fees. It may save you money in accounting fees, but it's certainly a lot easier from a bookkeeping standpoint and from a bank account keeping standpoint. So you could keep one bank account for the entity, but you want to keep separate books and records as to the income and expenses of each separate entity. So I'll give you a case in point why you should have an LLC. I have a client who recently got sued from a former tenant. Now, he owned this property in the early 2000s, so he hasn't owned the property since like 2004, 2005, and he received a lawsuit for a parent that was claiming that their child got lead poisoning while living at their property. It was a 2-family home or 4-family home, something like that. Now, interestingly enough, he told me that this person had sued him years ago, and the case had been dismissed, and we did some research as to why they could sue again, and they were now suing on behalf of the minor who was becoming 18. So if anybody's familiar with something called the statute of limitations, that doesn't apply to a child who's a minor until they turn 18. So this person, and I don't believe that the first lawsuit went anywhere, is trying to come back and sue on behalf of the minor to my client, the new owner, I believe the owner prior to my client, who may not even be alive anymore, and really probably just looking for money. There's a plaintiff's attorney. They're looking for money. They're going to try and settle with the insurance company. We had to dig up, do some research. We found the insurance company that he was originally insured under, and they have stepped in at this point. But without the LLC to give him personal protection, he would be more concerned about his other assets because of these crazy suits that people are just trying to get money out of the insurance company, and so forth. From what my research was, and I believe I did it back when the first lawsuit came, the lead poisoning is very unlikely in an apartment unless the child really ingests a lot of, like eats a whole windowsill of a window, not just living in the apartment. Or you'd see people getting sick all the time. It was an old building, so you can't remove all the lead paint. And I believe he complied with the laws and everything. But it's what I call a slap suit. They're just trying to get money out of the owners, the former owners, and so forth. And that's unfortunately what plaintiffs' attorneys do. They meet somebody, they get a hold of a case, they work on contingency. If they think it's got some teeth to it, they're going to try and file it and see if they can settle something with the insurance company. I would guess they would settle this. It won't go to trial most likely, but that's the case. So don't be comfortable just because you think you have an umbrella policy. Also, reality of life. People miss premiums, checks get lost, policies get canceled for different reasons. If your policy gets canceled or lapses and you don't realize it, or you do realize it, then you got to run out and transfer your properties into LLCs and get it all done. It creates a bit of a problem. So always better to be protected from the beginning. Now, there are some nuances if your properties have mortgages on them. I'm not going to get into this here, but you can talk to your banker, talk to your local counsel as ways to deal with it. It adds a little bit of difficulty in terms of transferring these properties and setting them up, but you certainly can do it to protect yourself. So that's the Tuesday morning update. Today is April 27th, and April 28th. And I'm Mitch Beinhacker. If you have any questions, you can always go to my website, beinhackerlaw.com. Send me questions. You can post them on LinkedIn or Facebook below this video. And I'm always available for free consultations. Also, as I said before, check out the podcast, The Accidental Entrepreneur, available on iTunes, Google, Stitcher, Spotify, I believe iHeartRadio, and TuneIn, which is the Alexa app. And, be sure to subscribe and tune in. We're talking to a lot of interesting people during the pandemic. I've been connecting with people all over the world who are entrepreneurs and small business influencers around the world. And I can hear all of our conversations coming out in the coming weeks. So enjoy the rest of your day.